Hi everybody, welcome back to 10 Minutes with Griffin. I'm your host, Griffin Bridgers. For today's episode, episode 152, we're going to look to some often overlooked gaps, especially in the estate planning world, that really come into play in marital agreements. Typically those are known as prenuptial agreements, but we'll dive into some of the gaps and terms that are really relevant here and look at some things that you may have recognized and you may not have, but either way, we're creating not an all-inclusive list, but maybe just some hot button issues that, based on my personal review of prenuptial agreements, I tend to see missing from the ultimate document that's presented to me by my clients. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. And as an added bonus, I'm going to start trying to give away copies of the slides to those who are more interested in the written materials. So if you'd like a copy of the slides, you can email me at griffin.bridgers@gmail.com. Now, prenuptial agreements are really a colloquial term for marital agreements, which usually are entered into prior to marriage, but sometimes in some states can be created after marriage as well, with certain requirements we're not going to get into in terms of how you make them valid and enforceable. But the ultimate intent with this type of agreement is that you're going to determine the property rights of each spouse or estate upon the termination of marriage. Now, divorce is usually the hot button issue here, so prenuptial agreements do a good job of addressing divorce during life, but oftentimes they tend to gloss over the fact that the death of a spouse also terminates the marriage. And there's a lot of planning issues that come into play, and you can't just necessarily rely on the boilerplate language of the prenuptial agreement to take those into account. So, there's some common estate planning terms where, there are things that are done right and are addressed. So the most common things you see are, for one, sometimes there's a waiver of statutory rights, like the elective share, intestate share, family allowance, so on and so forth. That's a pretty common provision in a prenuptial agreement. You might also have treatment of spousal gifts as separate property of that donee spouse, unless you're doing that for purposes of equalizing the estate, which we'll address in a few more slides. How that used to be a pretty common element, but has kind of gone by the wayside, but maybe something we need to bring back in a different form. And also you tend to have, with respect to qualified retirement plans, things like a waiver of any joint and survivor rights that would otherwise be mandated under ERISA. Now, those are common elements, but there's a lot of elements that tend to get left out of prenuptial agreements, some of which you might have thought of and some of which you might not have thought of. But in my view, these are things that should be addressed more often. The first one is the portability election, because when one spouse dies, the other can, as personal representative, make the election to preserve that deceased spouse's unused estate tax exclusion for the survivor. And that's really a valuable tax attribute for the survivor. And it's a tax attribute and really an asset that prenups often fail to address. So, what I think would be helpful is to clarify how that unused exclusion is used within the prenup, because especially in a second marriage situation, you have a situation where maybe there are children of the first marriage of the deceased spouse, and they don't benefit from that portability election, whereas the stepchildren of the deceased spouse might get the benefit of that portability election. So what the prenup could do is shore up that if that portability election is made, some or all of it should go to the benefit of the children of the deceased spouse. Another thing that is often kind of sloppily addressed is the effect of divorce on your estate planning documents, whether it be wills, trusts, beneficiary designations, otherwise. So, sometimes you have state law that backs you up here. And the line of demarcation is the issuance of a divorce decree. So in some states, once an actual divorce decree is issued, then there's a presumption created that each spouse has predeceased the other for purposes of any already existing estate planning documents or beneficiary designations. And obviously those could be updated after divorce, and that presumption of being predeceased is overcome when you can show that yes, you did documents after the fact that provide something to the spouse who would otherwise be presumed to have predeceased. Now, in those states that don't have that type of presumption, it's really important to make sure that estate planning documents and beneficiary designations are updated after the divorce. But if you don't get around to doing that, the prenup can create a great backstop, even if you're in a state that has this presumption, because what you can do is expressly state in the prenup that that presumption applies as well, regardless of where each spouse might live and where the couple might divorce, if that does indeed happen. Where after divorce, that presumption of having predeceased each other carries over, not only to just the receipt of economic benefit under the documents, but things like maybe fiduciary appointments. And that could be any number of things: personal representative, trustee, even a trust advisor or trust protector. And it could extend beyond that too, to simply the power to name fiduciaries for parts of an estate plan that don't affect the survivor or the survivor's children. And it's also common that maybe stepchildren are included in the estate plan. Those are the children of the surviving spouse. So it might be a good idea to extend that presumption of predeceasing to them as well, so that if you're only including stepchildren in your estate plan because of the marriage, it's natural to look at the fact that when the marriage terminates, you may not want to provide for those stepchildren anymore. And until you can get around to updating the documents to do that, the prenup can fill that gap and say, hey, those children are treated as predeceasing you and are no longer beneficiaries under your plans. Now, this is a presumption, so you can give it an express waiver. You can say, hey, if you do any documents before divorce, you can say, I'm expressly waiving that presumption in those documents. Or if you do documents after divorce, then obviously that would overcome that presumption at that point as well. Now, this presumption only kicks in at divorce. So what happens if you have a divorce in process at the time that one of the spouses dies? This can be a huge deal, and a lot of people gloss over this. But if you have, for example, a spouse who initiates the divorce process, maybe by filing a petition for divorce or legal separation, and then one spouse dies before the divorce is finalized, you lose out on the benefit of that state law presumption. So if you're going to create that presumption of predeceasing for purposes of divorce, you need to extend that out to situations where you have a divorce or legal separation in process. Once again, also giving the out where you could have this presumption that's overcome with a waiver in documents or through documents that are updated after the petition is filed. Use of estate and gift tax exclusions is another huge deal. Now, there's usually a presumption that any assets that are transferred to a spouse are spousal gifts and will be treated as the separate property of that spouse. Now, it used to be, especially before portability, which we previously discussed, that spouses would equalize the values of their estates so that they could guarantee that their, at the time, much lower estate tax exclusion could be maximized. In other words, that they had enough assets to shield, or really apply that unused estate tax exclusion. And when that happened, there was typically language that says, hey, those are not intended to be spousal gifts. These are really just estate planning transfers. So at divorce or at death, those assets come back to the estate plan of the first to die, or the first to die controls the remainder beneficiary of those assets. Now, even though we don't have estate equalization as a common tactic anymore, we're now in a position where a number of spousal gifts are being made for estate and gift tax purposes. So if that were to happen, you could end up in a situation where maybe you have gifts made to an irrevocable trust that are kind of like this equalization approach. They're designed to use up some exclusion during life. The only difference is when that exclusion is being applied. And that would be the case, for example, with a SLAT that's funded during life, a spousal lifetime access trust where the surviving spouse is a beneficiary. And in that case, there's usually a presumption that that transfer to the trust would be a gift to the spouse and would be the spouse's separate property. So the question is, do you want that presumption to apply to those types of gifts? And if not, the prenup should address that and remove that presumption for certain types of spousal gifts, which are really designed for estate and gift tax planning. Similarly, if there are transfers to the survivor that are required under the prenup, those should be addressed, obviously, in the estate planning documents, as we'll see, but often the form of transfer isn't addressed. I've seen a number of prenups where there's really just an outright transfer of wealth to the other spouse that's mandated. And that has obvious creditor risks and other risks where, for example, the first spouse to die doesn't control the remainder beneficiary of those assets. So because of those types of creditor risks and control risks, it might be more effective to leave those assets in a marital trust or a credit shelter trust. So in drafting the prenup, that should be a consideration, that if you're going to leave wealth to the surviving spouse, should that be held in a trust, and who are the remainder beneficiaries of that trust going to be? Now, there's another piece to this where you may want to extend certain spousal waivers as well, maybe to rights under remote contingent disposition clauses. It may seem intuitive that a waiver of intestacy rights would extend to the remote contingent disposition clause, but that may not be the case. All the remote contingent disposition clause does is incorporate by reference the intestacy laws and distribution scheme, but it doesn't apply intestacy. So you may want to have language that also says that waiver extends to anything that the spouse could otherwise receive under that remote contingent disposition clause or under any sort of default contingent beneficiary designation. Now finally, there are some items you can't necessarily address in the prenup, but you may want to make sure those end up in the estate plan of either or both spouses. For one, does the estate plan contain all the gifts that are required under the prenup to be satisfied in the event of the death of one spouse? So that should be addressed. Another thing would be powers of appointment held by spouses. It might be a bad idea, especially in a second marriage scenario, because with a power of appointment, they could be used to disinherit their own stepchildren. So that can run afoul of the intent of the first spouse to die, that those assets go to their children. So you may want to limit powers of appointment or even omit them if that's a consideration. Also, there is usually a survivorship presumption that kicks in under the documents, where maybe one spouse is deemed to survive the other. And we already kind of talked about that presumption, but if you have that presumption under your prenup, is that consistent with what your documents say? And I think you'd be shocked to find out that oftentimes it is not. As I mentioned, the remote contingent disposition clause is another situation where maybe that could be a hook where a separated or divorced spouse could still try to challenge a will or trust to get something through that remote contingent disposition clause. And that could be shored up easily by simply saying that you'll distribute assets as if the deceased testator or settlor is unmarried at the time. And that simple change can cut off that spousal benefit. And then finally, disclosures, especially for outside trusts, are important. And that's a common theme for prenups that we're not going to get into here, but you need to really address outside trusts that would otherwise be separate property, and really address not just disclosing them, but how those might be treated in a situation where the distributions from that trust might be used for the benefit of the marriage, where they're commingled in a common joint account, or where maybe they improve a house that is used by a spouse who's not the beneficiary or otherwise, and make sure that none of the use of those distributions can cause those trusts to become separate property. So lots of tidbits there on prenups. So if you do draft these or review them, hopefully that helps you to have some good ideas for your clients. As always, if you have questions or topic suggestions, or if you'd like a copy of today's slides, please email me at griffin.bridgers@gmail.com. Thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.